You got me that as a gift.
I did.
Congratulations on your acquittal last week.
Thank
on that
you.
important case. Well done.
Thank you very much.
You know, you had a period of time. You got a law degree in India.
Yes.
And then you went to the United States and did your master's in the United States and worked with a criminal law firm that did a lot of work in the sexual assault area. And as we all practice in that area, I think we do a few of those cases, right, Dee?
Oh, just a few.
Yeah, so we do a few of them. So we have, fortunately, a lot of viewers from the United States, the UK, and other jurisdictions, and they keep talking about, loving to learn about the Canadian system and a Commonwealth system. So I thought it'd be interesting, and thank you for coming on for your first time.
Thank you for having me.
Oh, you're welcome. We'd like to have you on many more times.
Absolutely.
To talk a little bit about some differences in the United States, also a little bit with India too, because they're a Commonwealth originally.
They are.
The system is very similar.
Right.
So I think it'd be good for us to talk a little bit about the differences and then really talk a little bit about what we have in Canada versus the United States and what we have to deal with.
Absolutely. So India, US, and Canada, they all three are common law jurisdictions. They come from the same... Substantively, law is pretty similar. Procedurally, they differ a lot. So, for example, in India, we don't necessarily have jury systems, but you have that in the United States, you have that in Canada as well.
Yeah, and in the United States, they'll litigate everything in front of a jury. So that's one important thing. So even a very minor offense like an impaired driving case will be a jury trial. It's really rare in the United States to have what they call a bench trial, which is a judge alone trial.
It is, absolutely. I mean, you also have to consider the fact that the judges in state courts, they're elected. So people, normally do wish to have jury trials there because you want to be in front of a jury. It kind of depends, because here in Canada, you do have the option of being before a judge or a jury. You decide depending on the cases. You don't have that liberty in India as such. So that is a major difference procedurally between them.
Can I call timeout?
Yeah.
So you said something really important, state judges.
Yeah.
So can you explain a little bit about state judges and being elected?
It's interesting. It's a very, so I remember back in the US when we were doing, for example, bail hearings, right? You are appearing before a state judge, and there's something known as getting bail, there's something known as being out on a bond. State judges are elected, federal judges are appointed, and state judges, based on they have these concepts that they're really tough on. For example, gun laws. So if you have, I remember doing a bail hearing, it was a youth. It was in Georgia sometime in 2015, and we had this youth, he was in possession.
That was not a fart, it was the leather, okay? I don't fart on camera.
He was in possession of a gun, allegedly. Thank you. Allegedly. But what happened was that some judges are so tough on gun crimes that this individual, remember, we're talking about a youth. The bond that he was allowed on was $1 million. And this is somebody who's not going to be able to make.
Yeah, so it's essentially detained. Bless you, honey. Right. So let's just talk for 1 second. So a state judge will preside over what type of offenses? So leaving aside a release from custody when being charged, let's talk about trials for a moment. Will state judges deal with state offenses? And can you just explain jurisdiction versus federal and state in the United States? And again, anybody who's watching, if we slightly get it wrong, please forgive us. We're just trying to talk a little bit about it now because there's a point we want to make.
Right. So it kind of depends. So the way US works is that what is not reserved for the federal government is left for the states to decide. So criminal law is not necessarily like Canada. We don't have just one criminal code that we follow throughout the country. Every state is different. They have their right to decide.
They have their own statutes.
They have their own statutes,
with their own laws,
penal
which are
code.
similar to other jurisdictions.
Exactly, yeah.
But it's not necessarily homogeneous across the country.
It's not.
Diana?
This is why I have so much trouble, because I have this nonprofit where I get contacted by people all across Canada, in the US, different countries. But the States is very difficult because it's difficult for me to even learn, because I can give people some idea of what to expect. I can't give legal advice, obviously, but because they're so different from state to state, I'm just like going, where even are you? And then each state is like, it would be impossible for me to be able to figure out how to give any sort of education. And generally what I try to do is say, okay, well, this is probably about how long it'll take. This will be like, these are the steps you're going to have to, but like,
yeah, so it's important
I don't know what to say.
The United States,
it's crazy.
State by state, has jurisdiction over local state law. Yeah. So they will have their own statutes with respect to criminal offenses within that state, which will include everything up from drinking and driving, assaults, domestic assaults, sexual assaults, homicides, etc. Yeah. If it crosses a border, it becomes a federal jurisdiction matter. Like a perfect example is drug trafficking. If it crosses over a border, or you put, campaign finance in the mail and you send it over, they're federal jurisdiction. But in a state, you will, if it's within the state, like a sexual assault case that we typically deal with, or domestic assault, it's going to be state prosecuted, and you'll be in front of a judge. And so your first instance trial will be in front of a judge who is elected.
Yes.
I found that really weird when I first encountered it. I was looking into a case in Oklahoma.
Let's talk about that for a moment. Yeah. No, go ahead. What were you saying? Like, I don't want to shut you down. It's such a foreign concept to us.
It is.
So I was helping with a wrongful conviction case in Oklahoma, and as I got looking more and more into it, then I became aware that not just the judges are elected, which, for us would be like, we have a very strong belief in independence and
of the judiciary
from the legislative branch, and so electing them almost becomes legislative. But it's very dangerous because then they can make decisions based on if an election's coming up, right?
That is always a concern, yeah.
Yeah, and then also the prosecutors are elected. And so then there's a concern because prosecutors, like I remember there's a judge in the States.
Hold on. The district attorney's elected.
Yeah.
But those underneath the district attorney are all...
Yeah, but the district attorney is like, they make very important decisions about, who to prosecute and how to prosecute. And
the policies for their office.
Yeah, and I think the independence is, a really big concern when that's going on. I think the Canadian system's better. Can you talk about that from experience
for a little bit?
When you have judges and they are being elected, the issue is how are they going to decide a particular case? So let's talk about a judge who's deciding a gun case, okay, based on just the example that I gave. Now, if the elections are around, he is going to be tough on it. And he's not going they're going to be tough on, on the crime. So you do have the concern of, are you really being impartial here? Are you really being rational here? So you have that concern. You're not necessarily going to say it, but you do wonder. And the fact that the judges are elected is, of course, a concern.
So that's why the United States clings on so tightly, and I don't criticize them at all for this, to the concept of a jury trial. So the trial of your peers is extremely important, and you can have it for misdemeanor offenses. Yeah. So a misdemeanor offense is what we'd call similar to a summary conviction offense in Canada. Yeah. So it's the lesser offenses that that attract far less of a penalty. So in the United States, you can have a trial on a drinking and driving offense, a simple assault offense, etc., which we don't have here in Canada. You're only entitled to judge alone. And that may be the check on having a judge who's publicly elected.
I see it that way.
Yeah.
But they still make, and this is interesting because we've talked a lot about new rules of evidence in Canada and so on, and even in a jury trial, judges make important decisions that affect the fairness of the trial, and some of those decisions are about the admissibility of evidence.
Right.
And so there's a couple of things that because I know a few lawyers down in the States as well. They're of course outraged that we have these new laws where we have to essentially turn over all the defense evidence prior to trial.
Appalling.
But not only that, there's a thing, and you know a lot about this because you've done a lot of work in the area, but we have a thing called Brown and Dunn, which this one lawyer that I spoke to, he was just flabbergasted, I guess would be a good word for it, that we have to put to a complainant, we have to put what our defense theory or what we expect our guy to testify to. We have to suggest all of those things. But did you want to explain Brown and Dunn a little bit?
Yeah. So, yeah, and I've been in the United States and I've been part of cases in the U.S. just because of clients in Canada that had to go down to the U.S. So what Diana's talking about is Brown and Dunn is a case that says if you want to challenge a complainant or a witness for the prosecution on certain material points, you have to challenge them on those points. And that inevitably relies upon what your defense of your client is, especially if you're going to call your client to testify. So let's take a very basic example of stuff that we do. So let's say it's a homicide, and we think we're going to be calling our client on a self-defense. You have to put to one of the main witnesses on the self-defense that what you saw was that the victim in that case, who's now deceased, had drew the weapon upon Mr. Such and Such and was about to shoot him, and Mr. Such and Such reached into his coat to defend himself. Or in a sexual assault case, what happened was that my client had approached you and you started kissing and you were touching him and you told him that you wanted to have intercourse, and then after you had intercourse, there was an argument that you had about X, Y, and Z, and that's why you've made up this allegation. So in other words, we're putting to the witness what evidence our client is anticipated to say at trial to give the witness a fair opportunity or complainant to explain themselves. It's called a Brown and Dunn in Canada, which is a case.
To either agree or to deny.
To deny.
Because the idea is that you don't want to ambush the witness, you want to give them a chance to explain, so you suggest to them.
Right. And in the United States, you're not required to go through that same rigor to put the case to a witness. Now, that's not always the way good criminal lawyers in the United States will conduct a cross-examination, because good criminal lawyers in the United States will do that in any event because they need to get in front of the jury why the witness is not credible. And that is often tied to the defense theory that you have, whether you're going to call your client or not. So this really is tied into the intricacies of an effective cross. But we have the rule and they don't in the United States.
And it was interesting because he was outraged that we had to go through that process. But then when I mentioned that to you, you're just like, why wouldn't you? And I was just like, yeah, it's really interesting how you can look at cases so differently and embrace rules, just like we've embraced the new rules of evidence.
Not farted again.
I know.
Yeah, like
we gotta fix that chair.
Yeah, I either
need
squeak
some
or
cushion in there.
Yeah. So, cross-examination is an art, and in order to be effective at cross-examination, there has to be a coherent theory to your defense, and it has to be put to the witnesses and to the complainant. And to be effective, there has to be a reason for asking the questions, and I don't know another way to say it, but you've got to put that theory through to the witness. I can't imagine that if I traversed the United States to conduct a trial, I would be any different. And I've had the benefit of knowing some very talented U.S. criminal lawyers where we've had cases together, and they did similar things. I like the idea, however, that you're not compelled by law to do that, because there may be a tactical reason. And in Canada, if you don't comply to that, there can be the argument made by the prosecution that there should be a diminished value to the cross-examination and hence the witness's evidence, your own witness's evidence, because you did not put that to the complainant or the witness for the prosecution. That is an issue. I have to say, I err on the side of the United States to say it shouldn't be ground in stone. And again, the case law in Canada is quite varied. You don't have to put everything, but you have to put the meat to them.
Right. No, that happens because I remember in one of my trials, and I made so many suggestions because I just had to get my client's story out there, that, there was a point in time when I was told that, by the Crown that, this was not put to the complainant, but the meat of the argument has already been put. So right. I know I do not have to put each and everything, but
Correct.
You know where I'm going with this. The judge knows where I'm going with this. Now the complainant knows as well where I'm going with this. So yeah, it is. I feel it's a frustrating process, and it kind of comes down to your strategy, because sometimes I would like to ambush if I had to. I mean, in the US you can do that, because here's the difference. So I know, for example, we talk about 276, 278 applications here. You have to disclose, everything that you have in your possession. In the US, especially I'll talk about Georgia because I have experience there. What happens is that if you are in possession of something, and if you're trying to use that in trial.
Like what?
let's say if I have any evidence, be it anything, text message or like, cell phone, whatever it may be, I have to disclose as long as I'm doing it during the chief. If I'm going to be using it in chief, I have to disclose. But if I'm trying to use them in my cross-examination, I don't really have to disclose them. For example, cell phone records. If, let's say, the complainant says, yeah, I didn't call your client on so-and-so date, I didn't call him. Well, I am in possession, somehow I'm in possession of cell phone records. And, these cell phone records I'm going to be showing to you. Even just to refresh your memory, you made this call. Well, I'm not going to necessarily get an objection that I got them. Where the hell did I even get these messages from, or these cell phone records from? So the rule, the hard rule that you have to disclose your materials in Canada is not the same in the U.S., at least in Georgia.
Quick question, quiz. Is there any jurisdictions in the United States where you have to have reciprocal disclosure?
Could be.
Palm trees. Out west.
Florida.
Schwarzenegger used to be governor.
California.
So there are rules in the United States in some jurisdictions like California where you have to have reciprocal disclosure.
Yeah. Again, it comes down to the states, right? The states decide the rules. So
Insane.
yeah. You have the federal rules of evidence, but you also have state-specific rules. So that's where they differ.
But let's talk about this. So in sex assault cases, when we have to bring an application to talk about other sexual activity and or disclose any type of messages or pictures or communications in our possession that we want to cross-examine on, there is not in existence in the United States the same hard, fast rule that we have here, that we have to bring a motion, vet it through a judge, get approval that it's admissible and not offending myths.
Well, they do have rape shield law that you're not trying to harass the complainant with whatever you're trying to do, but there's no such rule as the 276 and 278.
Yeah, the rape shield law, which we've had here for a long period of time, is absolutely justified and correct. And they have it in the United States as well, that it's not because
The core of it.
Yeah. Because you had sex before does not necessarily mean you would have consented or you're less believable. Like, that's just common sense, and that's absolutely accurate. But we are now operating on 7,000 myths, or as we'll get to in another episode, what myths some judges invented.
I know, that's the problem.
Supreme Court of Canada.
They keep coming up with new things that are allegedly myths.
Yeah, like you're not guilty. But leaving that aside, there is not the same hard and fast rules with respect to vetting this before a judge. Is that correct?
Yes, that's correct. At least in terms of Georgia that I know of, because of my experience.
And New York State, which I'm quite well aware of.
And New York, there is no such rule that you
and Florida, which
show,
I did a case in.
What you are in possession. Again, the rule.
Not just show. It's not just show. We have to vet it and ask for permission to show that it's relevant. To show that it's relevant, there has to be a very detailed application, essentially
that level
disclosing
of detailed
our case.
Application, as far as I know, it does not exist.
I would imagine if it was suggested in the United States, in any of these jurisdictions, that we have to disclose our defense to admit messages between the complainant and the accused in the sex assault case, 90% of the lawyers in the United States would have a coronary.
Yeah.
For some of this stuff, yeah.
Yeah. They'd be like, are you
Especially
kidding me?
now, because now we have to disclose stuff even if it's the subject matter of the charge. So
we've talked about this before, but can you explain that so that everybody gets that again?
So even like 276 was designed to be quite tough in order to prevent all sorts of mischief. And like, as you said, most of that legislation is right outside of the
absolutely legitimate, yeah,
the new myths that are being created. But it was exempt from that if the subject matter of the charge is the actual moment of the allegation, like the events of the allegation that constitute the alleged crime. So if it was related directly to that charge and it wasn't something that happened prior or something that happened after, it would absolutely be deemed relevant because it's the subject matter of the charge. But now with the new legislation, if you have it in the form of a document, a text message, a photograph, a video, anything that takes the form of some sort of a document or content in your possession, it doesn't matter if it's the subject matter or the charge. It goes directly to what it is you're accused of. You still have to ask for permission to use it.
Right. So the Supreme Court of Canada and JJ, which we've been over a few times on podcast, have said that if you have a document or a record which includes a message some form of communication, including a recording, etc.
An actual video of the sexual
or a
act that
video
you're
of the
accused
actual act, which is the subject matter of the charge. So the actual allegation, that has to be disclosed in an application and then subject to an analysis at the court to determine whether it is relevant and admissible. So that exception no longer exists here.
But I know, like, I have talked to people about some cases in the States where they were denied the ability to use emails and so on in their case because they were alleged to be engaging in some sort of a rape myth. So I know in the States they have similar concerns, but their legislation's not quite
It's more
so
lax.
strict.
Yeah.
Yeah, so let's talk about that for a moment. So there are instances in the United States where judges can exclude prejudicial evidence.
Yeah.
And they can exclude it on the basis that it's engaging in myth-based reasoning or is not relevant. So it could be myth-based and it's not relevant, or not relevant for other reasons. So the judges have that inherent discretion in the United States to do that, and that can become part of a hearing that we call a voir dire. In the same United States, they call it voir dire.
No, there's a difference.
What do they call it, voir dire?
No,
A voir
there's
dire?
a difference. So I had to deal with this
Voir dire?
concept of voir dire.
I know. What do they call it in the United States?
It depends on like where you are. Like if you're up north, the way you pronounce it is different. But I know what you're talking about.
Yeah, so you have a hearing about whether the evidence is admissible.
Right. So
then you
that's
have
motion
that
and
argument with the
eliminate.
judge.
But what voir dire is basically in the U.S. is called jury selection. It's not what it is here. But that's when I was here and practicing in Canada, I was like,
Yeah, I forgot what they call these evidentiary hearings, but they have evidentiary hearings. We can have a voir dire where we call evidence, but they have evidentiary hearings where they'll talk about what's admissible. And judges do have the discretion, state to state, as to what can be admitted, and they can exclude evidence based on myth-based reasoning or other reasons. So it does happen.
But all of this stuff, I mean, it sounds so technical, but it's so important because you're going into trial. And if you aren't allowed to bring your evidence with you, you can end up like having your hands behind your back. Or
let me ask a question, and this is interesting because again, you have experience with the United States. What's better? So here now we have this very rigid approach. We have fairly good guidance now from the courts, the Court of Appeal and the Supreme Court of Canada, with respect to admissibility of other sexual history evidence and records. What's better? Is it better to have this very rigorous process we have in Canada, or on an ad hoc sort of basis in the United States where you may be left up to the whim of a judge, depending upon the case, where there isn't the same clear-cut rigor? There is case law, but you may wind up in a case facing a judge regardless of whatever the case law is, says, look, no, I'm not admitting it.
Here's the thing. If you're in front of a judge alone, which is more likely to happen in Canada, the judge knows what evidence they've excluded for whatever reasons they decide, but they've seen it.
yeah.
Whereas with a jury, and that's more likely to happen in the States, if evidence is excluded prior to trial, the jury doesn't know what they don't know. Mm-hmm. They have no idea that they're not permitted to think about something or whatever. They just have no idea that evidence exists in the first place.
I'm just positing the question because typically these will be jury trials in the United States, and we have been lamenting for a while now about this process here, and I still agree with the dissent in JJ, where I think this is unconstitutional legislation, but regardless, our job is to know the law.
Roadmap for wrongful convictions is what the dissent said.
Excuse me.
Yeah. A roadmap for wrongful convictions.
Well, that's what they said, and
in the dissent from the Supreme Court.
And I agree. But now knowing what the playing field is, just from experience, I'm much more comfortable now with the way it's rolling out. And on a case-by-case basis, I would be a little bit more concerned about having excluded from a jury just because of a judge's perceptions than what would be now a fairly coherent, legislative structure and case law structure. Like, just again, we were talking. You have a state case in the United States, and I may be wrong about this, and viewers can pipe in. But you get a judge who's up for election, and sex assault is one of those things in the United States that's a bad thing. I mean, it's a bad thing here too. But you're up for election, so you want to protect complainants, and you've got a complainant, maybe some similar act evidence, and so you're going to carefully cull the defense ability to call and cross-examine on certain evidence.
Dangerous.
Very dangerous, no?
Yeah.
One thing that I would.
And does anybody win on trial in the United States, really?
Sorry?
If there's a problem with the
win
trial,
Of course they win.
Do they?
Of course we win.
one thing
They-
I
their
got to
jails
say,
are full of
Canada
people.
is far superior. Is appeals process. It's so frustrating watching appeals happen in the States because there's so many different levels, and you can win on an appeal, and then
There's a Supreme
there's like
Court in each
it
and
goes
every
back
state,
and forth and
so-
back and
Well,
forth.
there's the circuit courts, the
The
I know.
circuit courts are federal courts, the state Supreme Courts are different.
The appeals in the States.
I
to
need
me
to
are
drink
just-
I
Like 2-3
understand that.
states are gonna make one circuit. Like the 11th circuit would be Florida, Georgia.
But here's
next.
one thing. Here's one thing. I absolutely think the United States is 100% better in when it comes to appeals.
that once you're acquitted, it's final.
That's yeah. There is no appeal.
There's
from
finality
the other side. Yeah.
of an acquittal by a jury.
And the individual
You
does not
can't.
have
The
to go through the
state
process again.
cannot appeal that. We have a fairly narrow ground for the Crown to appeal an acquittal by a jury or an acquittal by a judge in Canada. Yeah. That said, you can't appeal it. In the United States, that's unassailable.
Right. Yeah.
And the reality is you could go to trial, be acquitted, Crown could win an appeal, or prosecutors could win an appeal, and then they can appeal. You go back to trial, and then you get acquitted again, and they could keep. How many times do they get to appeal? Because they could technically.
We're going to talk in another episode about a case where there was an acquittal at trial, went to an appeal. The judge wrongly overturned the acquittal and ordered it back for trial. And it went to the Court of Appeal now, and it's an acquittal again. And it just goes to show you the incredible changes and machinations that happen in Canada. I think some finality when you've determined that a jury, and I believe a lot in this, that a jury of your peers has decided on the evidence that was deemed admissible, not guilty. That's the end of it. That's as far as the state should
There was a
reach.
case in Alberta where the person was acquitted. It became a high-profile case because there was a whole bunch of media around that particular case. It went back to retrial. He was acquitted again, and the prosecutor said that they were considering appealing it again. So that could have happened. And I remember one of our best court journalists, who's unfortunately passed away, Christy Blatchford, said,
Oh yeah, she was great.
"How many kicks at the can do they get?"
Yeah.
And the truth is, they could have. They could have tried to appeal it again.
Can we talk about something that you may have experienced in the United States? So I find it always very interesting in a case in the United States where it's like semi-high profile. And they're doing the investigation, and there's an arrest, and the case is like literally litigated in the media.
Yeah, that happens.
Like everything.
Yeah.
And so there was that murder of, I forgot which state it is, and it's horrific for university students. And
Oh, yeah, this recently happened. One person walked in.
is that Arizona? And so they've arrested somebody, and the investigation into the arrest was impeccable. I mean, just following it on the media and how it was laid out with the warrants and everything else. Right. I mean, really, high-end, sophisticated police work. That said, I don't know if it's absolutely necessary to release all that information prior to a trial, because you need to protect the integrity of a trial. Like that's extremely. I find that just troubling.
And you know what's troubling?
Although, as just an observer, I was like, wow. That was great work. Look they had warrants and this and that, and they triangulated cell phones, and they were able to get all sorts of, like, car was pulled over just by happenstance by a police officer. They had video cam. Like, it was f***ing amazing.
Right.
But I don't think anybody should know that until the case has gone before a jury.
Because it's concerning for if think of it in this way. So you have it's all over the news. Everybody's watching. It's just not like in one city or one state. The whole country is watching.
Yeah.
Where do you change the venue? Everybody's watching it, and you're gonna draw these jurors from who are watching the same news or potentially have already seen it. Sometimes if you have concerns that maybe it's tainted, maybe I do not want to be in this jurisdiction, maybe you want to apply for a change of venue, where do you go? everybody.
No,
wanted to see it.
and you know, if you know your chances in the United States, I mean, you get defense lawyers speaking to media. You maybe get a press release. It's like we don't do that in Canada.
Yeah.
And it's very difficult, and that's why I like the Canadian process. That there's an arrest, maybe there's a press release, and that's it. You don't hear anything until the matter has been dealt with.
But sadly, that's not the truth, right? So, I mean, it happens. And also, they want to publicize everything in the name of public interest, that something like this has happened.
I love this topic. So let's just talk about it for another minute. So in the United States, cameras are allowed in the courtrooms.
Right.
Now, one state is extremely restrictive about cameras in the courtroom, to the point that cameras generally are not allowed unless an exceptional circumstance is allowed by a judge. What state is that? Raise your hand if you know.
I do not know.
New York.
Really? I don't know.
New York State. They're very regressive in New York, according to U.S. media, about allowing cameras into the courtroom. Now, I happen to know this, and it's just rearing its head now because somebody notable has been accused of a number of offenses in the United States and had to appear before a court in New York State and be arraigned on charges. And there's a big debate as to whether cameras will be allowed in the courtroom, what that means for transparency. But New York State does not typically allow cameras in the courtroom. Now, of course, in Canada, we don't allow it.
Except for one place, the Supreme Court.
The Supreme Court, because that's the ultimate end of a case. That's the appeal. We've had it in the Ontario Court of Appeal on a few occasions where there was something momentous about exonerating somebody who was wrongfully accused. James Lockyer had been a member on a team for many of these wrongful convictions. These were typically murders with flawed identification evidence, and DNA exonerated them. But we don't allow cameras in the courtroom. And I think that's the right decision.
Yeah.
But coming from the United States, what do you say? Now that you've come over here, transferred over to the Canadian jurisdiction.
I'll be honest. So I prefer not having the cameras in the courtroom. Why? Because, it's not just the privacy interest of the complainant, it's also the privacy interest of the accused. Because at the end of the day, you are innocent until proven guilty. You should not be crucified while you're going through the process.
What about the honesty of witnesses?
Yeah, people are watching.
What about the jury?
Yeah, that as well.
Like, you're on camera as a jury across a country. I mean,
they say
will that force you to make a decision one way or the other?
This is an interesting difference between Canada and the States, too, is that jury members can speak about their deliberation process down in the States. Whereas in Canada, you're barred from permitting telling anybody, especially media, about how it is you came to your verdict.
Which I absolutely agree with. I think it's very important to protect the jury. I think it's very important for juries not to be interviewed because their deliberations have to be free from influence and free from public scrutiny. The minute you got the public going, they're idiots for saying that, one way or the other, that's when you're going to get perverse verdicts. I think cameras in a courtroom can lead to perverse verdicts because any number of things can happen during the course of a trial where you have cameras that may either inhibit a witness from wanting to testify or a complainant in a very sensitive case. It may also cause them to exaggerate or showboat. Right. Of course, if we were to allow cameras in Canada, I had put forward the idea because we wear robes in Canada. So in Canada, like the British system, we have to wear robes. So we have like a vest.
We just don't have the hair.
We have a vest that I can't really fit into anymore and tabs and robes. I was thinking that what we should do is have like Nike, Adidas, Reebok sponsor lawyers. We either the swish or the thing on it. We can get cards. We could do a whole thing.
Yeah.
No? Stupid idea? Okay, I'm just being silly. But I really do think cameras not being in a courtroom, I think that enhances the truth seeking process. Yeah. I don't think that level of transparency enhances it.
Yeah. But I will say, I've seen a couple of cases in the States where, because jury members were permitted to speak to the media, that grounds of appeal became available because of things that the jury member said to the media about how much weight they put on something or what caused them to be swayed, or they find out that there was some sort of influence from an outside source. So
Or they'll lie about something.
So I have seen cases where something that a jury member said to the media ended up becoming, or said on social media, ended up becoming a grounds of appeal.
Right. I think that happened recently in a case as well. I forget which one it was, but the juror was wearing a T-shirt, and he lied about his, things that he thinks about,
Affiliations?
or rather his affiliations, or something that he's vocal about. I think he lied about it, but there was a picture of him wearing a T-shirt about the ideology that he
Denied.
Yeah. So I think
So that leads me to one more. Are we running along?
And
I love this topic.
And I think it happened in this one. What's her name? This lady in California. She was really young, billionaire. They made a documentary about her, Elizabeth. She made this, I forget her name, but it recently happened. It'll come to me, and I'll say it.
Well, let me just talk about this, because you said something about the ideology of a juror.
Right.
Well, what do they get to do about juries in the United States in selection that we don't get to do here?
Oh, we get to ask questions. We get to ask a lot
just
of
tell me about
questions.
that, 'cause you were there.
I remember preparing
Just tell me. I'm so
many
interested.
questions.
You get to ask questions? That's so
Oh
cool.
my God. I have seen jury
You
selection.
mean get to know what's in their head, maybe?
It happened. I remember this one. We were doing a murder case, and the lawyer I was working with, she took the whole day to do her jury selection. She was so precise in her questions. You could tell some people were getting irritated, but she was asking each and every question that she had. I prepared like this fat. I had over like 100, 150 questions she could ask, and she was choosing whatever she wanted to ask. But you don't have that liberty and the luxury in Canada to do that.
So, but what are you asking questions about?
Well, you can ask them, for example, do you have do you have a card? Like, do you have these stickers on your card, for example? Because that kind of gives me an idea about your ideology or what you're affiliated with. Do you have stickers on your card? What kind of stickers? What organization do they belong to? If you're doing,
So you want to look at ideological perspectives,
Right.
religious allegiance, belief structures.
Yeah, we don't want to tell them what case they're going to walk into, but have you had issues? Anybody in your family has had a criminal, a violent death or a violent, interaction or something with the law. And if somebody says, I've had a bad interaction with the law, or my husband died, or my father died because of somebody doing because of a robbery, for example. They're going to be not necessarily
impartial. So we can, judges try and screen certain things like this out with their instructions or their questions that they pose to a jury that they don't directly ask. But lawyers in the United States are allowed to ask a reasonable amount of questions of a potential juror to tease out ideological issues, religious issues, bias, and
without giving a reason as to why I'm striking them.
Right. So we don't have that challenge for cause here in Canada.
Preemptory challenges,
Yeah, they're gone.
I know, I heard.
Thank you, Justin. Thank you.
But
I'm going to thank you for something else in the next podcast, Justin.
But it kind of depends on the state again, because the states make these rules. And for example, the preemptory challenges you get, for example, in Georgia, you would get 6. In Minnesota, you would get 10, depending on whether it's a misdemeanor or a felony case. So the amount of preemptory challenges you get depends on the state and what kind of offense you're dealing with.
But you get to ask questions.
100%.
That's so interesting.
And the one thing I remember out of this jury selection, I had the privilege of meeting someone whose job is to just sit in during the trial and just look at the jurors, just read their face.
Jury selection experts.
They're consultants.
They tend to be jury consultants. They tend to be psychologists.
It blew my mind. I had no idea, and I met this individual as a student, and I was like, "You do this for a living? I didn't even know you existed."
Yeah, so I had a case, a conspiracy to commit murder, where the late Eddie Greenspan was counsel for a person. I represented the other one on this conspiracy. It was a very high-profile case. And Eddie had flown up from the United States an expert on jury selection. Mm-hmm. And of course, in Canada, we could ask nothing. Right. But he was trying to assess from at least the list that we had, and of course we could know occupations, what might be an appropriate jury depending upon occupation and other things. And so they have a real science for it in the United States, and whether you believe in it or not. Yeah. I'm a firm belief that in Canada, with the right instructions, juries take their job very seriously and try and transcend their biases. Right. But it's an incredibly interesting process in the United States just to how much emphasis is placed on this analysis.
Yeah.
And we don't have it here. There's so much more. We didn't even talk about India because
You don't have the jury. I mean, yeah, we have the bench system, and sometimes you do have more than one judge, and the more than one judge depending on specialization that
you
they
work
may
for a very
have.
high-profile lawyer in India.
Extremely, yeah. So there are 2, 3, the former law minister, Ramjit Malani, then we have Satish Manishinde, my Indian, folks would know. But yeah, they're high-profile lawyers working on really big cases in India. So.
But, it's interesting. There is a lot of feedback that we get, because we have viewers from there, about a lot of the inequity in the justice system in India.
Yeah.
And I think one thread that maybe we'll just close on is that many jurisdictions are finding the lack of investment in the defense system and in fairness. And we're seeing in Canada, underfunding and chronic underfunding of legal aid. We see that in the UK, we see that in India, and the United States. They have a better federal public defender system, which is generally well funded. The state public defender system is less well funded, but they're dedicated people. But there is this chronic deficit for those who need to rely upon public defenders or a legal aid system. And we can visit that in a later time, but that's something that we're seeing growing across multiple jurisdictions, which is bad and sad for our justice
Well, we've
system.
known for a long time that it's going to go into a crisis state in terms of underfunding. Nothing's
We're
really
at
doing-
it. We've been at it for a long
We've
time.
mentioned before, in the UK, they went on strike because their legal aid system was so poorly funded.
Alberta was on strike recently. We were supporting Alberta lawyers because they were right at the strike section because they were just so incredibly underfunded, and these lawyers aren't able to make a living defending people who need defenses.
And they need to be defended.
All right,
Well,
let's
hopefully
click.
that's something that
Yuvi,
improves.
Thank you for having me. My glass is empty, but
thank you for joining us.
Thank
Again,
you.
congratulations on the win. Will you want to come back for another podcast on some stuff?
Yes, if you'll have
just
me.
absolutely. You're
Thank you
you're
very
just up
much.
the office over there. Come on down.
I'll just walk downstairs.
And in the meantime, everybody remember to like, subscribe, hit notifications, leave
Share.
comments, share.
Send us messages. We love it all. Thank you very much. Good night.
Thank
Happy
you.
happy long weekend.
Yeah.